Hey everyone, and welcome back to today's video. We've got several sovereign citizen cases to cover, spanning multiple court appearances. We'll start in Michigan, where an individual claiming to be an American state national attempts the classic argument that a debt applies only to their so-called strawman, not the living person. Let's get into it.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared, and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just said, I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm...
No, we had a hearing on, maybe. I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
This situation reminds me of that time a sovereign citizen tried to subpoena every single voter in Harris County, something like 5 million people. And just like that case, this guy is about to be denied access to Chase Bank's accounting data as well.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender and they borrowed from me.
You want to know how to spot a sovereign citizen without them saying the words? This is it. IQ in the double digits, credit score right there with it. He's almost certainly the American state national type, the ones who think every line of credit triggers some secret government deposit into the bank. And when it's time to pay the bill, they believe they can wipe it out using fake money from a secret account that doesn't exist.
What did they borrow from you?
My personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. This. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You
Is
took
that-
a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th, there's a problem.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating.
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set.
All right, so this case is essentially wrapped up. There will be a hearing on the motion for summary disposition on January 9th, and you know I'll bring that to you when it happens. Now, before we move on to the next case, this individual actually had another appearance on the same docket for the exact same issue, just with a different credit card company.
All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for inconvenience, so that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Part of reconsidering a previously ruled on motion, when one party was unable to attend the hearing, especially if that party is pro se, is essentially giving them a do-over. For that to happen, two requirements must be met. First, there must be a valid reason for missing the original hearing. Since this was a Zoom hearing, an internet outage is considered a valid excuse in the court's eyes. Second, the party must present a meritorious defense. A meritorious defense means a credible legal argument or evidence that could potentially allow them to prevail in the case. Simply wanting to exercise due process does not qualify as a meritorious defense. Point 5. And I'm sure you spent all day carefully drafting your affidavits on some extra tasty construction paper, but maybe you just didn't hear what the judge actually said. You already filed your answers, and in those answers you failed to dispute a single claim made by the plaintiff. That alone was enough to meet the burden and justify the judge ruling against you. And as for your demand for due process, congratulations, you got exactly that.
Okay, all right, here's what we're going to do. I'm setting a date. So what, do we need discovery on this? What, Mr. Gothal, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
Normally, this is where I'd say, all right, let's move on to the next antisocial dumbass. But unfortunately, this one wasn't done talking.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set.
Perfect response. Now let's move on to the next guy, another sovereign citizen, who's about to learn the hard way what happens when you refuse to identify yourself at a formal hearing that you requested.
All right, we're all set. Thank you,
have no words.
Mr. Arnold, I have ruled against you.
I
am
have
allowed
evidence.
to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
Earlier, you stated that you were appearing on behalf of the defendant as his attorney. You're well aware that you cannot appear on behalf of anyone, including yourself, without being a licensed attorney and providing a valid bar number.
Mr. Moore, you can come forward, sir. Yeah. Oh. Okay. Are you Sherman Moore?
I am not.
You're not. Okay. And so are you appearing on Mr. Moore's behalf?
Yes,
Okay,
I am, yes, here for that matter to handle the matter that's at hand.
okay. And are you an attorney, sir?
I am the attorney, in fact, for the said name at hand here.
Okay, so you are an attorney representing Sherman Moore?
Yes, I will be handling the case for Mr. Moore.
Okay. And are you licensed by the state of Washington to practice as an attorney?
I am not licensed or a bar member or a lawyer or anything of the such, but I am here as a beneficiary executive for the said name.
So let me guess, you're the beneficiary of all the rewards tied to that name, like if it wins the lottery, but somehow you're not responsible for any of the consequences, like when it breaks the law. Now that I think about it, that would make life incredibly convenient.
Okay, before I respond, let me see if the city takes any position. Mr. Gunderson, is the city taking any position on the representation of Mr. Moore in this matter? I don't even know if you're appearing on behalf of the city in this matter.
Good morning, Your Honor. Will Gunderson, prosecuting for the city. Your Honor, the city does typically appear for the contested hearings in which officers have been subpoenaed.
Was an officer subpoenaed in this matter?
Yes. Your Honor, the officer is present. Officer Berglund is here. Your Honor, my position at this point is to request a short continuance in this case. The basis being I rely on the Judicial Information System, or JABS, review that information relevant to the particular case. Within the last 20 minutes, the JABS database has gone down. Oh.
And do you take a position on the representative of Mr. Moore appearing in his stead this morning for purposes of the hearing?
Your Honor, ultimately, the city would defer to the court on whether or not the individual is present is allowed to act on behalf of the defendant. To cut to the chase, Your Honor, this sounds like it might be a sovereign citizen type of situation. I don't know if the individual that is seated here is in fact the defendant, or if he is a completely separate person, separate and apart from the defendant that was pulled over at the time this incident took place. So that is a red flag, so to speak, or a question mark that does get raised in the city's mind, for which the city does believe that a further inquiry by the court may be appropriate. But ultimately, Your Honor, with regards to any representation, city will defer to the court.
All right. Thank you, Mr. Gunderson. So, sir, I'm going to ask you to identify yourself for the record, please.
I am one of the people.
I'm sorry?
One of the people.
Okay. Are you or have you been previously named or identified by the state of Washington as Sherman Moore?
I am not Sherman Moore,
Okay.
the entity in which you speak of.
Okay. And do you have any relationship to Sherman Moore?
I am just the beneficiary of that name.
Well, the prosecutor has already identified himself, and the police officer who was subpoenaed is right there in the courtroom next to you. So if you're looking for the verified complainants, I'd say you've already found them, sitting as close to the shallow end of the gene pool as they're ever going to get.
Okay. Well, the problem that we have here is that at this point, based upon the record that I have before me, sir, you are not authorized to represent Mr. Moore as an attorney in this matter because you are not a licensed attorney by the state of Washington. And at this point in time, based on the record, Mr. Moore has not appeared in...
Oh, he's right here, sir. Sherman Moore is right here. The name in which you speak, he is right here, sir.
That, for the record, you're holding up a piece of paper.
Yes, the document, Sherman Moore, the entity in which you speak of, and one in which you this court intends to charge. So I am just a beneficiary of said entity. That is all. And that's why I'm here. So basically, I'm trying to find out the nature of said charges that pertain to said name.
Sure, certainly.
Is this a criminal or a civil matter is what I'm trying to figure out here, sir.
This is a civil matter. So Sherman Moore, or an individual identified as Sherman Moore, was issued an infraction here in the city of Lakewood on September 5th, 2024, and was ordered to respond to the issuance of that infraction, which it appears that he did, and requested a contested hearing in which he is asking to challenge the evidentiary sufficiency of the information relied upon by the issuing officer who issued the infractions or the issuance of those infractions. But by requesting that hearing, Mr. Moore, or the individual who was issued the infraction named Sherman Moore, indicated that he would appear in person as a living person here in court. And the problem that I have at this point in time is that based upon the record that I have before the court, Mr. Moore has not appeared as a living, breathing human being in this court in response to his request for a hearing.
I am simply just a man on the land that is here on behalf of that name as the beneficiary for that name.
I understand that. But at this point,
There's a claim being made. So therefore, like I said, I'm just here to understand the nature. You say it's a civil, so where is the verified complainant for said charges?
Who would have thought that if you don't actually show up to your court date, you're almost guaranteed to lose? The funniest part is that after the judge left, this sovereign citizen had that aha moment, realizing they just played the classic around and find out game, and they found out.
the verified complainant is the city of Lakewood, represented by the attorney on behalf of the city, who is seated in the courtroom to your left, appearing down to my right. And Mr. Gunderson, I'm just going to ask you to formally identify yourself for the record.
Thank you, Your Honor. Will Gunderson, prosecuting for the city. I am licensed to practice law in the state of Washington. My bar number is 46991.
So the plaintiff in this case is the city of Lakewood. They are appearing here this morning through counsel, or this afternoon through counsel. It also appears that the officer who issued the infraction to Mr. Moore is also present in court in response to the subpoena that was issued for his appearance. It appears that the only individual who has failed to appear for this hearing is the respondent, Sherman Moore. And so at this point in time, with the matter having been on the calendar at 10:30 a.m., it's now 12:04 p.m. Given that Mr. Sherman Moore has not appeared in person for this hearing, pursuant to the rules for infractions in Washington courts, the court will find that Mr. Moore has failed to appear and will enter a finding of committed to each of the 5 infractions. And I believe that concludes our court's calendar for today. So thank you all very much. At this point in time, the court will be at recess.
Understood, Judge.
Oh yeah, I'll do it in the, yep.
All right. Court is in recess.
So are we continuing or what's? Based off of what grounds of what?
Mr. Moore did not.
Sherman Moore is here. I am the man of the Moore, Sherman of the Moore family. I am not the entity in which you speak of. What? What kind of charade show is going on here? So what happens now? I have to file an appeal? Okay. So I'm being railroaded. So the officer never had to show or anything, basically on the basis that so the witness or the subpoena I never got to cross-examine.
No, you had the chance to cross-examine the police officer. That's why he showed up. Or I guess Sherman Moore had the chance. But as you said, Sherman Moore is nothing more than a piece of paper. And unfortunately for you, pieces of paper don't have mouths to speak in court, nor vocal cords to cross-examine witnesses. Looks like this one wasn't thought all the way through, huh? Alright, that's it for this video. If anything else happens with this guy, I'll be sure to bring it to you. If you enjoyed the video, hit that like button. If not, hit dislike, but don't forget to leave a comment below. And make sure to subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out. Music.